Good morning, everybody. Welcome to the third and final employment law update for the year. For those of you who don't know me, I'm Graham Damant. I'm a senior consultant in the Employment Law Department. I will be hosting you today. The purpose of these updates is basically to keep you up to date with the latest court cases. Despite the fact that we've now had the legislation in place since 1995, we find that the law keeps developing, and so we need to keep you up to date with those developments. And in addition, we try to make this update as practical as possible so that there's a whole lot of issues that hopefully you might need to apply in the workplace at some point in time. You will see that we know that we're presenting virtually. Accordingly, there are a couple of housekeeping issues. The chat function has been disabled. If you have questions, you use the Q&A function, and I will try to direct those questions to a participant to answer. I may not get to all of your questions, but I will try to find a place where I can fit them in. We will be recording the session, so the recording will be available. And in addition, the case citations will be sent to you afterwards. We've got a very full program of cases from the Constitutional Court, Labour Appeal Court, Labour Court, CCMA, High Court, so virtually all of the various courts that deal with labour issues. We are hopefully going to get through the agenda by somewhere between 10 and 10:30, but I will have a hard stop at 10:30, even if we haven't completed the full program. I'm going to kick off by introducing Talita. Talita is a senior partner in the Employment Law Department. She is our go-to expert on all things gender and all things discrimination. She's our expert in that area, and she's going to present the first case on equal work for equal pay, which is the case of UASA on behalf of Maritzburg and others versus Ekurhuleni Metropolitan Municipality. Talita, over to you.
Thanks, Graham. Good morning, everyone. Yes, this is an equal pay case that made its way to the Labour Court. And just to recap, Section 6 of the Employment Equity Act prohibits unfair discrimination in any employment policy or practice on a very wide variety of immutable characteristics and any other arbitrary ground. In this case, the two employees who are superintendents in the traffic department said that there is unfair pay discrimination because they are paid about 100,000 rand less than their comparative. The comparators are black people. Maritz and Bierman, the two complainants or applicants, are white people. And they say, was it not for their race, they should have received the same salary. Now, Section 6(4) of the Employment Equity Act says it is unfair discrimination if there is a difference in terms and conditions of employment between employees of the same employer performing the same or substantially the same work or work of equal value. That is the first hurdle that you need to get over. You must prove that you are performing the same work. It is horizontal discrimination, if we can put it that way, that is prohibited. It is not the wage gap that you are earning too much more than me, but it is people who are performing the same work, substantially the same work, or work of equal value that are treated differently. And not just that are treated differently, that are treated differently because of one of the listed grounds or an arbitrary ground. So that is the second hurdle that the applicants need to get over. They must show that the reason for the difference is actually that they are white people. And not that there is some other reason that is objectively justifiable that causes this difference. So in this case, both Maritz and Bierman referred unfair discrimination, Section 6(4) cases to the CCMA, and conciliation wasn't successful, and the matters then proceeded to the Labour Court. Because they were so similar, the two got combined. They are, as I said, superintendents, and their comparators are chief superintendents. Now, there was no evidence that the jobs are actually the same or of equal value. And in fact, the evidence and the concessions by the applicants showed clearly that the jobs were not of equal value. The chief superintendent's jobs were of a higher rank. They did additional duties. They had different tasks, and they also had different reporting lines. So in the circumstances, the municipality said you are not even getting over the very first hurdle, which is to prove that you are performing work of equal value or the same work or similar work. And on that basis, that case then fell flat on its face. The other thing that came up in this case was that these two employees had longer service than any of their comparators. So they were employed 5 years in the one case and 9 years in the other case, longer than their comparators. And they said, you know, actually, we should have been made chief superintendents by now. It's not right that these comparators of ours have gone through the ranks and we are stuck here at the superintendent level. That is a completely different dispute. That is not an equal pay dispute where you are saying I must be paid the same as my comparator. In fact, that is saying I must also be promoted to the level where these comparators have been promoted to. And by implication, you are admitting that they are at a higher level, they are performing additional tasks, and that the jobs are not of equal value. So it is not to say that there isn't a dispute there, but that wasn't, you couldn't bring that claim under section 6.4. So this claim of Maritz and Bierman was dismissed, and that was the end of it. Any questions on equal pay?
There's nothing up in the Q&A, so we'll move on to discrimination, and you can touch on the case of Chazibani.
Good. Again, very interesting. Aubrey Chazibani, and he sued Montego Pet Nutrition for unfair discrimination. And I must say it is really, really nice that we are now starting to get very clear guidance from the courts on what is unfair discrimination in our law. Judge Kroon in this case set out in the very first paragraph that it is not all sins in the workplace that amounts to unfair discrimination. And I want to read to you. It is not sufficient for an employee to demonstrate that his employer has acted unfairly. It is also not sufficient for an employee to show that his employer's conduct was irrational, arbitrary, capricious, or even mala fide. Allegations of victimization or maltreatment do not of their own amount to unfair discrimination. It is not enough to demonstrate favoritism, cronyism, or nepotism. What you need to show is unfair discrimination, and that is a high threshold. Where the discrimination is alleged on one of the grounds listed in section 6.1, it is presumed that there was discrimination. And it is, well, it's actually established. Discrimination is established. And it is presumed that it is unfair. So you can still say, well, you know, yes, there was discrimination because I said only African males of a certain age must apply for the role of playing Nelson Mandela in a movie, but that is justified. So if you are relying on a ground that's not listed, it is a very high hurdle to get over to prove discrimination. And you need to prove that there is a ground on which you are relying, and that ground is affecting your human dignity in a comparably serious way, as would differentiation on one of the listed grounds. And as this judge said, he referred back to other cases when he speaks of cronyism and nepotism. Those things do not necessarily reach that threshold. It needs to be something that goes to your human dignity. Now, in this case, fascinating, the employee's partner was sexually harassed by a fellow employee. And this employee, Aubrey, then took the employer to court and said that that sexual harassment affected his human dignity because it was his partner that was sexually harassed, and that he suffered damages and an affront to dignity and needed to be compensated for that. So he said he felt completely humiliated by this act that was done to his partner, and he felt a huge sense of disappointment that he wasn't able to protect. And as a result, he suffered psychological and psychiatric illness, and he subsequently needed to get treatment from a psychologist, a psychiatrist, and a medical practitioner. This was made all the worse because the alleged perpetrator was not dismissed. But when all of these things came to the fore and the employer dealt with this issue, they asked in the inquiry, what did the complainant, the actual victim of the sexual harassment, want to happen? And she was very adamant that she didn't want him to lose his job, notwithstanding the circumstances that gave rise to the sexual harassment. So it was in these circumstances that the employer needed to deal with it. Then the other thing that this employee said was that there were disciplinary charges brought against him, and he was victimized because he raised this issue about the sexual harassment of his partner. But the evidence showed that actually those disciplinary charges were completely unrelated to this case, and he was not the only person in respect of whom the disciplinary charges were brought. And in fact, the disciplinary charges were withdrawn. So there wasn't a disciplinary action. He's still an employee and everything is fine. In any event, he didn't refer a dispute to the CCMA complaining of an unfair labor practice in that regard. So he couldn't, in the words of the court, dress up an unfair labor practice dispute or a delictual dispute, for that matter, where he had suffered psychological harm, as an unfair discrimination dispute under the Employment Equity. The court said him being a partner of the victim of the sexual harassment is not a listed ground, and therefore it would fall within the arbitrary ground for unfair discrimination. He didn't articulate that very clearly, so this is what the court then worked out was the ground for alleged unfair discrimination. And it said, no, this is not sufficient to affect your human dignity in a similarly serious way than would discrimination on one of the listed grounds. And then the court said, by way of amplification, an employee has no right of recourse in terms of labor legislation because he can demonstrate that his employer had been nasty or unkind. So that is, even if there is proof that an employer regards an employee as a troublemaker or a problem employee, that still doesn't amount to unfair discrimination for purposes of Section 6. And the court then held that there was no unfair discrimination in this case, and this case was dismissed. Fascinating.
Very interesting, yeah. And then I think you've got a second one on discrimination as well, the case of Ishmael versus Life Intabeni Hospital.
Yeah, this is very interesting, Graham, and it has to do with the Life Intabeni Hospital dress code. In terms of their dress code, there is a principle bare below the elbow. So you cannot wear anything from the elbow to your hands. And that is a safety precaution in the hospital. This dress code applies to everyone that works with patients. And it says that this policy is absolutely critical so that clinical sterility and safety to patients is not compromised. The policy is nuanced, so it does recognize that there are cultural and religious imperatives when it comes to dress, and the policy tries to accommodate these differences. But this is the principle: we are not compromising on patient health. And we are talking here about someone that worked in ICU. So it is a situation where there are hectic bugs and very, very ill people. So the policy, as I said, is nuanced. It said we are happy to accommodate different religions. For example, for Islamic dress to be worn, that is in order, but only headscarves from a selected uniform range must be worn, and employees in a clinical environment may not wear the jihad. Then also this rule about bare below the elbow, that applies. And interestingly, it also talks about rope and animal skin must be worn in a manner that doesn't pose an infection control risk. Skins worn for religious purposes should be worn on the arm above the elbow or around the waist beneath the uniform. So this is the policy that the employee then, Ms. Ishmael then had an issue with, because according to Sharia law, she had to wear full Islamic dress, which meant that she needed to be covered from the elbow to the hand. She engaged with Life Hospital and she said, you know, can't you reasonably accommodate me? I can put on these surgical gloves every time that, you know, we change patients when I come to the different patients. And it is not that that was rejected out of hand. The hospital actually looked into that possibility, but then it, you know, got its calculator and it saw that it had about 322 employees who follow the strict Islamic rules in relation to dress. And by allowing everyone to change gloves between working with patients, as opposed to just simply sanitizing and making sure that they are scrubbed, it would cost approximately 35 million per annum. And the court said that was out of proportion. Well, the CCMA, that is out of proportion with the the harm that it is trying to prevent, and this will actually cause undue hardship for the hospital. And ultimately, the public would have to bear the costs. So the suggestion of reasonable accommodation wasn't possible in this case because it would lead to undue hardship. And therefore, the court said, no, you actually have to comply with this policy. The policy is sound on medical and scientific grounds, and it does not amount to unfair discrimination.
Thanks, Dee. There's a comment in the Q&A that the Chazabani case is kind of an example of a case where, you know, Wagley said that the court has been cluttered with cases that should never be there in the first place. And the question being that Chazabani should never have been there in the first place, as it was a kind of a non-starter, not being an employee. I don't know if you've got a comment on that.
Yeah, Graham, these cases help us to crystallize principles. So it helps us to see, you know, why certain cases succeed and why others don't. Especially in equal pay cases, there are very few that have been successful. So just because that is the case, you know, we mustn't prevent them from coming to court because it helps us to navigate this very interesting area of law. I must also add that, you know, this issue about the delictual claim that existed potentially, the court was very clear that it didn't say it is definitely a slam dunk that the employee had a delictual claim that he could pursue. But that would have been actually the cause of action. And interestingly, I'm actually looking at another case at the moment where an employee was removed from her particular school, put on an excess list to go and work at another school. And she was very unhappy about that, and then claimed a deal. And in that case, the court said, no, honestly, you know, your so-called, you know, stress and angst about, you know, going to teach at another school. We are in the public school system. We can move people where we need them. That's not a deal. So at least we are starting to get these cases through the civil courts as well. So yeah, but it helps us to prevent the wrong cases going to court.
Thanks, Dee. Thank you very much. So we're going to move on to the automatically unfair dismissal case of MISA versus the Great South. I'm not sure if there's more than Great South, Melissa. And Melissa Cogger from our senior associate in our Cape Town office will be taking us through that case. Over to you. Thanks, Melissa.
Thanks so much. So the case is Motor Industry Staff Association versus Great South Auto Body. It's a Labour Appeal Court decision that was heard earlier this year in September. And this dealt with the question of whether an automatically unfair dismissal on the basis of age is present when an employee works past their retirement age and then is later dismissed because of their age. So in this particular case, there was a written contract of employment in terms of which it was agreed that the employee's retirement age was going to be 60 years old. He then reached 60 years old, but the company didn't ask him to retire. And he carried on as usual. And then 9 months later, the employer wrote to the employee and informed him that his services were going to be terminated in a month's time because he had now reached his retirement age. So it was common cause that the dismissal was a reason on the basis of age. He then brought a claim in the Labour Court claiming an automatically unfair dismissal. And he argued that because he continued to work after the age of 60, there was a tacit agreement that he would continue to work until the age of 65, because that was the age that was set out in the Provident Fund rules, and that the employer, by allowing him to work past the age of 60, had waived their right to rely on retirement age. So there is a section in the LRA that says it's not an automatically unfair dismissal on the basis of age if an employee has reached the agreed or normal retirement age. And that is the section that the employer relied on in this case. And the court held that that section doesn't prescribe a time frame within which a dismissal must take place. All that's required is that the employee must have reached the retirement age. So the section allows an employer the right to fairly dismiss an employee based on age at any time after the employee has reached their agreed or normal retirement age. So the focus is not so much on when an employee reaches their retirement age, but rather that the employee has already reached or passed the normal or agreed retirement age. And the court said that this was consistent with the purpose of the section, which allowed an employer to dismiss employees who have passed their retirement age in order to create opportunities for younger members of society to work. But the court said that this is different if there is actually a new or agreed retirement age. That could be either an agreement that is written or tacitly agreed. And then if that's the case, the employer can only rely on that specific section of the LRA once the employee has already reached that new retirement age. Thanks, Graham. You're on mute.
Couldn't get my mute button off. Thanks very much. We're going to then move on to the two harassment cases. Ros, I think you're presenting on them. The first is Amatoli District Municipality versus CCM Others, which is a LAC judgment. So let's move on to that. Over to you.
Thanks,
Ros.
Graham. Thanks. Good morning, everyone. All right, so this case is actually an interesting one. It's a claim arising out of Section 60 of the Employment Equity Act. Now, for those of you who don't know, Section 60 provides that an employer is liable for discrimination, which includes harassment on a listed ground, in circumstances where the employer fails to take appropriate steps to prevent harassment in the workplace, alternatively fails to appropriately deal with a claim of harassment that's brought to their attention. In this case, an employee, we'll call her Ms. P, alleged that she had been subjected to ongoing sexual harassment by one of her male colleagues, Mr. F. She claimed that when he first started working, he would sorry, can you hear me, Graham? I'm getting a temporarily muted sign on my screen.
We can hear you perfectly, Ros.
Okay, great. Okay, thank you.
Especially loud. Now you're muted. Now you put mute on.
Yep, got it. All right. So what happened is when he first commenced employment with the company or with the municipality, he was required to share an office with her. According to her, he then used his position and he used to touch her intimately and even went so far as demanding oral sex. Her claim was that she complied with his demands because she was afraid she was going to lose her job. So this persisted over a number of months. And once he moved into his own office, it continued as he would call her into his office so that the conduct would persist. At some point after this has been going on for a significant period of time, it appears that she told her boyfriend about it, and he then told her that she needed to lay a grievance. She waited, I think, a further 4 months before eventually lodging a grievance. So she lodged the grievance in about November 2015. It did appear that for the period about July 2015 through to December 2015, Mr. F had been taking issue with her performance and had been speaking to her because she was apparently not performing and had made various reports on that. So that's just as an aside. After the employee lodged the grievance, the company convened a grievance inquiry. But on the day, I think it was that the grievance inquiry was due to continue, the employee contacted the company and said, look, I've been booked off ill. So the grievance did not continue and was due to be postponed. Thereafter, the employee took annual leave and only returned to the office in January. When she returned to the office, the company representative attempted to reconvene or convene this grievance inquiry, and Ms. F was completely non-responsive. So she didn't respond to any attempts to have the grievance inquiry held. This carried on, and there were various attempts to have this grievance hearing. She did nothing about it, or would say, look, I'll get back to you when I'm ready. And eventually the company representative reached out to her and said, look, you said you'd come back to us with dates. And her response was, well, it's not for me to schedule the grievance hearing. So the company said, fine. They scheduled the grievance hearing in May eventually, and then it proceeded. The outcome of the grievance was that the municipality could find no evidence of sexual harassment. So the grievance was dismissed, but the chairperson of the hearing did, however, say, look, we need to provide this employee with emotional support, and also recommended that she be transferred to a different area so she wasn't reporting to this guy, because there was obviously some friction between them. She was dissatisfied with the outcome, and she referred a dispute to the CCMA, in terms of which she sought compensation in terms of Section 60 from the employer. At the CCMA, the employee gave her evidence. Mr. F was called to testify. He gave his version, and there were various documents that were put forward as evidence, which included email exchanges between Ms. P and Mr. F, WhatsApp, screenshots of WhatsApp, screenshots of text messages. Now, these communications seem to indicate that there was a consensual relationship between Mr. P and Ms. F. But for some reason, the commissioner refused to admit them into evidence. And he said something along the lines was, well, he wasn't satisfied that these communications hadn't been altered, which was a very strange finding, because I don't believe this was raised by Ms. P, and she never actually said that they were an inaccurate or false documentary evidence. Be that as it may, the commissioner refused to allow it. Ultimately, he found that she had been sexually harassed, and he ordered that the municipality pay her 150,000 Rand in compensation. The municipality was unhappy and approached the Labour Court on appeal. The Labour Court's attitude was, look, sorry, we're not going to interfere with credibility findings of the chairperson and of the commissioner, and they ultimately upheld the arbitration award, and the matter then went to the Labour Appeal Court. Now, the Labour Appeal Court started by considering sexual harassment and had the following to say on sexual harassment. Sexual harassment is the most heinous misconduct that plagues a workplace, and it poses a barrier to the achievement of substantive equality in the workplace. So they viewed it, very seriously, which is correct. However, the LAC then said, we've got to look at the evidence holistically. You can't look at one instance, you need to look at all the evidence. And included in that, they looked at the documentary evidence and found that this documentary evidence ought to have been admitted by the commissioner, and they couldn't understand why it hadn't been. So they analyzed Ms. P's version. They analyzed the inconsistencies as well that arose in her version. They analyzed Mr. F's version, and they analyzed the documentary evidence. And they found that ultimately the documentary evidence established that Ms. P was not sexually harassed, that there was a consensual sexual relationship between them. And one of the SMS messages that they referred to was one where she had said to him, you know that I'm hungry for you. Now, seriously, sweetie, what are your plans for the rest of the day? And the LAC said, but this is completely irreconcilable with her claim that she'd been sexually harassed. They were also concerned by the lengthy delay in her reporting this. So, they looked at this and they said, but, she didn't provide an explanation for why there was this delay at all. And ultimately, the LAC found that there was insufficient evidence that she had been sexually harassed. The LSE also said, well, even if she had been, if they were wrong and she had been sexually harassed, the Section 60 of the EEA doesn't provide for strict liability, as in the case of vicarious liability. It provides that only if an employer fails to take appropriate steps to deal with claims of harassment can the employer be held liable. And the LAC said that they didn't know what other steps the municipality could have taken. You know, they'd attempted on numerous occasions to convene the grievance. They'd offered her emotional support and guidance. They'd offered to transfer her somewhere else so she wasn't working directly with this individual. And the court said, we don't know what more the commissioner expected the municipality to do. So in that case, the appeal was successful. Any questions on that?
Thanks, Rosalind. There's nothing coming up in the chat yet, so we'll move on to the second of your cases. And then I think Mbali's got a load shedding issue, so I'm going to probably bring your matter up, Mbali, to immediately after this.
Okay, so my next case is FA versus the University of the Witwatersrand. It is an arbitration award by the CCMA. And it relates to claims of gender discrimination and gender bullying. So essentially, Mr. N was employed by WITS as the head of one of the schools. So he was in a very senior position. There were numerous claims against him relating to gender discrimination and bullying. And I think in the arbitration award, which is some 75 pages long, there were 27 claims that were identified of, you know, to show this sort of ongoing gender-based harassment and discrimination. Ultimately, Mr. N was charged by WITS, faced a disciplinary inquiry, and he was dismissed for systematic gender-based bullying. I think that's what the misconduct was described as. He was unhappy, and he claimed that his dismissal was both procedurally and substantively unfair. Now, these 27 complaints, there were various women who came forward with this evidence. So, you know, we had a number of women coming forward. Their stories were consistent, and they went from undermining female colleagues, ignoring them, disregarding issues that were raised by them, especially if the issues were raised that involved another male colleague. If a woman would say something and one of the male colleagues would say something else, he'd go, no, well, I believe the man. I don't believe what you're saying. He was, you know, if there was one of the female colleagues stood up to him or made suggestions or proposals that he didn't like, he would refer to them as being aggressive and difficult to work with. I think he often in discussions would, you know, point at various of the women and go, oh no, they're very aggressive, they're very difficult to work with. So constant undermining. He apparently also deliberately provided some of these female employees with incorrect information so that it would impact on their ability to perform. And I think in respect of one of the employees who was a lecturer, and she was conducting a field of research, and he basically said to her, yeah, well, look, you know what, you need to stop working on these hobbies, you need to get down to real work. So he was very undermining of the sorts of work that they were doing in the university. Now, the commissioner, in considering the nature of harassment, had regard to the relatively new Code of Good Practice on the prevention and elimination of harassment in the workplace. Now, for those of you who don't know the code, it deals with harassment on a listed ground. So it's based on race, gender, sex, any of the grounds listed in the Employment Equity Act. And what it says is that harassment is unwanted conduct which impairs the dignity of an employee. It creates a hostile or intimidating work environment, and it is related to one or more grounds listed in the EEA. So obviously gender, as we all know, is listed in the EEA as a ground of discrimination. So that's where he started. He then also looked at what types of harassment existed. In this regard, he looked at the code and he also looked at the WITS harassment policy. And he identified the following. So slandering or spreading rumors of an employee, conduct which humiliates, insults, or demeans employees in the workplace, deliberately providing employees with false information or not providing them with information in order to impede their work performance, and then general intolerance and bullying. So these are all examples of workplace bullying and harassment. He then went on to analyze the issues, and one of the other issues that was raised was one of the female employees was Italian. So apparently she was very vocal, she used her hands, she gesticulated, etc. And after a meeting, he approached her and said, listen, you know, people find your conduct offensive. Now, I know Italians and I know this is how Italians behave, but other people don't. So you need to tone it down. And she felt very humiliated and attacked because of her Italian heritage. So that was another example that not so much aimed at her as being a woman, but aimed at her as being Italian. Now, the concept of workplace bullying is linked to feelings of incompetence, to a sense of alienation, to anxiety that there will be consequences or there won't be promotional recognition, and creates feelings of inadequacy. So the commissioner took all of this into consideration when he started. And what he said is that generally harassment or bullying is persistent, unwelcome conduct, which creates a hostile or offensive, which is hostile or offensive and creates an intimidating environment, and it is calculated to induce submission. And this creates or includes a wide range of demeaning or intimidating behavior. He differentiated gender harassment from sexual harassment. And what he said in this regard is general harassment speaks to being the target of particular kinds of gendered remarks, so remarks about your gender based on, you know, being a female, etc. Whereas sexual harassment was sexual in nature. And in this regard, he said, what we're dealing with here is gender harassment. He said that he then looked at all of the incidents and he analyzed the whole case holistically. And he went on to find that the evidence of this revealed that there was a pattern of behavior that, you know, of gender bullying, that, you know, Mr. F deliberately drew out or, you know, attacked women, especially if they spoke out, if he felt that they were challenging him, etc. And ultimately, the commissioner found that his dismissal was substantively fair. It was interesting because he found in favor of Wits on every single one of the 27 complaints. And he said there was evidence to support that. In addition to finding that the dismissal was substantively fair, the commissioner then looked at the procedure followed, because he had also claimed that his dismissal was procedurally unfair. And what he had said is the charge sheet was very general, it was generic, no specifics were given, so he was unable to properly defend himself. And what the commissioner said is, you know, the code of good practice provides that you need to give an employee notice of the allegations with sufficient particularity, a reasonable time to prepare, the assistance of an employee or a trade union official, and an opportunity to state a case, and then notification of the outcome. And the commissioner said this, or confirmed the position that, you know, there is no need to conduct a formal criminal style disciplinary inquiry, and was satisfied that on the information that Mr. F was given, he was sufficiently well aware of the allegations against him. Certainly in the way he defended himself, it was clear that he knew what he was meant to respond to, and that ultimately his dismissal was procedurally fair. The commissioner also said that, you can then, in an arbitration, provide additional evidence. It's a hearing de novo, so if you need to then elaborate, you can, and ultimately found that the hearing was procedurally fair. Interestingly, in this case, the commissioner also ordered that Mr. N pay 16,000 Rand towards Witz's legal fees, which is quite unusual in the CCMA. Are there any questions on that, Graham?
Covered so far. Thanks, Ros. Ros, if you don't mind, I'm going to bring Mbali's topic up.
Sure.
She's dealing with inconsistent application of discipline, and it's a case of Nyhawu on behalf of Bukwa versus the Department of Health. Mbali, over to you.
Thank you, Graham. So this is a Labour Court decision, and in this case, the employee was employed by the employer in 2009, and then in 2019, he was charged with essentially stealing a bag which belonged to a patient at the hospital where the employee was employed. After being charged with stealing the bag, he was then called to a disciplinary hearing, where at the disciplinary hearing, he pled guilty to the charge, and he admitted that he had indeed stolen the bag, but that he had done so because his son needed a school bag, and even though he had given his parents money to buy his son the school bag, the parents took his father to hospital instead. After he had pled guilty, he was then dismissed. He took the matter up to the CCMA, and in the CCMA, the crux of his argument was that having pled guilty, the employer acted inconsistently by dismissing him in relation to other employees who he knows had committed similar acts of misconduct in the workplace, and that the employer in those circumstances opted not to dismiss those employees. And then the commissioner in the CCMA did not agree with him and found that his dismissal was indeed fair. He then, the employee then took the matter up on review in terms of Section 145 of the Labour Relations Act, and his grounds of review essentially centered around the fact that he argued that the commissioner in the CCMA failed to take into consideration the fact that other employees employed by the same employer who had committed similar acts of misconduct in the past were not dismissed by the employer, and the employer opted to allow and condone such behavior, showed leniency to those employees, and allowed the employment relationship to continue. In the Labour Courts, before reaching its decision, the Labour Court firstly pointed out the fact that the employee was quite brazen about his misconduct, where he pled guilty firstly in the internal disciplinary proceedings, and then again in the CCMA, he pled guilty to the charges, and his main argument was basically the fact that because the employer had condoned such behavior before, the employer should condone his behavior in his circumstances as well. So the court pointed out that it was quite clear that the employee was under the impression that just because the employer had shown leniency before, that a precedent had been set in the workplace, and that the employee should benefit from that particular precedent. So the court then reached the decision that it cannot be that an employee can engage in such serious misconduct, that is criminal misconduct, and then expect not to be dismissed simply because an employer has shown lenience to employees in similar circumstances in the past. The simple fact in this particular case, the court said, was that the court was not willing to tolerate the employee's acts of criminal conduct, and that the employer should not be obliged to tolerate and condone such behavior simply because it has shown lenience to other employees in the past. And the principle which essentially emanates from this case is that historical inconsistency cannot be invoked by an employee in circumstances where the underlying misconduct involves serious criminal conduct. The court held that it doesn't matter whether the employer had informed its employees that such behavior will not be tolerated, as or every employee in a workplace should know that conduct such as theft will not be tolerated. And it doesn't matter whether the employer had informed its employees that such behavior will not be tolerated and may lead to a dismissal. The simple fact in this case is the fact that the employer was not willing to tolerate the employee's behavior, and the employer should not be obliged to do so simply because of leniency that it has shown to other employees in the past. And the court finally held that there was obviously no merit to the grounds of review raised by the employee, and the fact that the owner of the property that had been stolen by the employee, even if it is accepted that the owner had forgiven the employee for stealing his property and that the employee had returned the property to its rightful owner, it is for the employer to decide whether or not the employment relationship between the employer and the employee had broken down. And the employer had concluded that the employment relationship had broken down, and therefore there were reasonable grounds for dismissal. So in this case, the Labour Court held that the review must fail and the application was dismissed.
Mbali, thank you very much. Thank you. Ros, back to you. We're going to deal with strikes and picketing and a Labour Court case of SACTU and its members versus KZN Marketing and another.
Thanks, Graham. Okay, this is, I thought, quite an interesting case. I quite enjoy the strikes and the collective bargaining. So what happened here is SACTU has a collective bargaining relationship with KZN Marketing. Interestingly, this case involved an intervention by the Labour Court in a partially completed disciplinary inquiry. Now, the ordinary principle is that the Labour Court does not have jurisdiction and will not interfere in disciplinary action unless there are exceptional circumstances. So the court had to look at this matter and determine whether or not it warranted or it constituted exceptional circumstances and warranted the court interfering. So as I said, SACTU had a collective bargaining relationship with KZN Marketing, and they had been engaged in wage negotiations. Ultimately, the wage negotiations deadlocked, and the union referred the dispute to the CCMA in terms of Section 64. Now, interestingly, with this case, KZN Marketing does not have its own premises. So it has various depots and sites where employees come in order to get their instructions for the day and to find out where they're going. And then they actually go and work at various retail outlets. So it's not your normal center, you come to work and your workplace is the same. They go and they work at these retail outlets. Now, after SACTU referred the dispute to the CCMA, the matter was set down for conciliation. Now, for those of you who don't know, the Labour Relations Act now provides that a commissioner, when conciliating a dispute over a matter of mutual interest, must ensure that there are picketing rules. So there must either be agreed picketing rules between the parties. If there are no agreed picketing rules, then the commissioner must determine picketing rules. And the Act says that the commissioner may not issue a certificate of non-resolution until such time as he issues these picketing rules. Now, the other thing to remember in terms of the Labour Relations Act is that over a matter of mutual interest, the process is wage negotiations if it's wages, deadlock, referral of the dispute to the CCMA, conciliation, and either certificate of non-resolution or the expiry of a 30-day period, after which the union can issue a strike notice and give 48 hours notice of the strike. So there is no actual requirement that there be a certificate of non-resolution in order for the union to call for a protected strike. So the conciliation meeting was held, and for some reason, it is unclear what the reason was. The commissioner did not issue picketing rules, and there were no picketing rules. Notwithstanding this, SACTU then issued a strike notice and gave KZN Marketing 48 hours notice of the strike. KZN Marketing took the view that the strike was unprotected because there were no picketing rules, and said there'd been non-compliance with the provisions of the Labour Relations Act insofar as the commissioner had not determined picketing rules, and therefore they said SACTU cannot call the strike. Notwithstanding that, SACTU is adamant that the strike was protected and the employees went on strike. KZN Marketing then issued various ultimata to the employees, demanding that they cease the strike and report for work. The striking employees ignored the ultimata, and ultimately they faced disciplinary action. Now, a disciplinary hearing was held, and the employees were charged with instigating or participating in an unprotected strike. At the disciplinary hearing, SACTU raised a point in limine and told the chairperson that the strike was protected and therefore there was no basis for this disciplinary inquiry. The disciplinary chairperson found that actually the strike was unprotected and said that dismissal was appropriate sanction. However, he said that notwithstanding the dismissal would be appropriate sanction, he said he believed that the employees legitimately believed that they were on a protected strike. So he was going to suspend the dismissal and issue final written warnings. SACTU was not happy with this. So at this stage, they then approached the Labour Court on an urgent basis to set aside this finding. So the first thing the court had to determine was whether or not exceptional circumstances existed. And what the court said is that the court has the discretion to interdict or to interfere in a disciplinary process if it is to prevent a serious injustice. And in these circumstances, the court said, given the nature of the dispute, they were satisfied that it was a matter that the court needed to determine. So the court then went on to consider the lawfulness of the strike. Part of SACTU's argument was that they never intended to call for a picket. So yes, I think the employees did actually embark on a picket, but they never intended to call for the picket, and there's no authorization for the picket, but that did not impact on the protected nature of the strike. So the question the court had to look at was, can a strike lose protection because the striking employees engaged in an unprotected picket? Now, KZN Marketing said that picketing rules were a prerequisite to issue a strike notice. The court, however, disagreed. And what the court said is, you look at what do you need for a protected strike? You need referral of a dispute. You need either a certificate of non-resolution or an elapse of 30 days from the date of the referral. You need a matter of mutual interest, and you need a strike notice giving 48 hours notice of strike. That's what you need. Whereas for a picket, there was a different prerequisites. For a picket, there must be authorization by a registered trade union. It must be in support of a protected strike, and the picket can take place at any place where the public has access or with the consent of the employer on the employer's premises, and then you need picketing rules. And what the court said is a picket is not a strike and a strike is not a picket. The two actions are regulated separately, even though a picket is conduct in furtherance of a strike. So ultimately, the court correctly, in my view, found that the strike was protected and that the chairperson's ruling was unlawful a nullity and of no force and effect. So I think that's quite an important case because it stresses the difference between picketing and strike. Now, had the employees been charged with participating in an unprotected picket or an unlawful picket, the outcome may very well have been different.
Thanks, Ros. Yeah, very interesting case. Thank you very much for that. We're now going to move over to the Constitutional Court case that deals with this whole issue of common purpose. And it's the case of Nomza versus Mbali Pipes, and is going to be presented by Amandla. Amandla, over to you. Thank you.
Thank you, Graham. Good morning, everyone. As previously stated, I'm presenting on the NUMSA on behalf of Aubrey Lulu matter against Mbali Pipes. So this is a matter that was held by the Constitutional Court in August this year. What transpired in this matter is that in July 2017, the company communicated a wage increase that was reached at a sectoral level bargaining. But the employees who were NUMSA members did not take the news very well, and they embarked on an unprotected strike, which culminated in the physical assault of Mr. Ferdinand Stephens, who was the company's head of human resources. 148 employees were dismissed following a disciplinary process after they were found guilty of 2 counts of misconduct, the first being the assault of Mr. Stephens, and the second being the participation in the unprotected strike. However, 40 of the dismissed employees were never identified as having been at the scene of the assault, and 1 employee only arrived at work late and after the assault had taken place. So while NUMSA initially challenged the dismissal of the 148 employees at the CCMA and at the Labour Court, they were unsuccessful at the Labour Court, as the Labour Court upheld the employer's decision. Then they went to the Labour Appeal Court, and then they only challenged the dismissal of the 41 employees who were never identified, or the one who only arrived at work after the assault had taken place. And there they challenged the substantive fairness of their dismissal. The Labour Appeal Court found that since there was no evidence that any of the 148 employees had disassociated themselves before, during, or after the assault of Mr. Stephens, common purpose had been established. Obviously, dissatisfied with the outcome at the Labour Appeal Court, NUMSA referred the matter to the Constitutional Court, which then had to determine whether the Labour Appeal Court created new rules on the proof of common purpose. And if it did, whether such rules accord with the requirement that dismissals be substantively fair. So the Constitutional Court found that the Labour Appeal Court had indeed created new rules in its application of the doctrine of common purpose by insisting that in order not to be found guilty under the doctrine of common purpose, bystanders must take positive steps to distance themselves from the violent act and intervene to protect others from physical harm. Now, the Constitutional Court found that these new principles had no basis in law and would significantly impact on employees where protected and or unprotected strikes take a violent turn. The Constitutional Court confirmed the application of the doctrine of common purpose as set out in the criminal case of S versus Mgedezi, which was a Supreme Court of Appeal judgment that stated that the doctrine of common purpose required the presence at the scene of the violence, which is also subject to the awareness of the violent conduct being committed. The intention to make common purpose with those actually committing the violent conduct, manifesting the sharing of common purpose by performing some act of dissociation with the violent conduct. And lastly, the requisite criminal intent, also known as mens rea. The Constitutional Court further confirmed its decision in NUMSA on behalf of Nganezi versus Dunlop Mixing and Technical Services that an employee's presence at the scene is not necessarily a requirement to attract liability or complicity. The Constitutional Court stated that to protect employees who are mere innocent bystanders, there must be proof on a balance of probabilities of the employee's complicity in the act of violence, including proof on the basis of the doctrine of common purpose. Otherwise, those innocent bystanders would be caught and be found guilty of action or omissions they never really partook in. In this regard, the Constitutional Court appreciated that there was a likelihood that the 40 employees who were at the scene when Mr. Stephens was assaulted but never identified as assaulting Mr. Stephens had probably a moral obligation, but were under no general legal obligation to intervene to stop the assault, and that their mere presence and observation did not satisfy the requirement for direct and or circumstantial evidence, proving that they in some form associated with the violence either before, during, or after it ended. Therefore, the dismissal of the 41 employees on the charge of assault of Mr. Stephens was found to be substantively unfair, as the principles applicable to common purpose had not been satisfied. The Constitutional Court naturally remitted the matter back to the Labour Court to decide the sanction on the second charge of participating in an unprotected strike only. Now, the Constitutional Court empathized with the employers in relation to the obvious difficulties that they face in proving an individual employee's complicity in violent acts committed during a protected and or an unprotected strike for purposes of disciplinary proceedings. However, the court reasoned that with advanced modern technological means, employers would be able to ameliorate those evidentiary difficulties. Now, given the Constitutional Court's attitude, it becomes imperative that when employers seek to dismiss employees on the basis of common purpose, it is established that the employees performed some act which shows that they associated themselves with the violence either before, during, or after it ended. The mere fact that the employees do not intervene to stop the violence or actively disassociate themselves with the violence will not be sufficient to prove liability on the basis of this doctrine of common purpose. It is also important, I believe, after all of this case, that employers take care of how they draft the charges, calling the employers to a disciplinary process. Charges drafted in a criminal sense may require that the necessary elements of that particular crime be proven, albeit on a balance of probabilities. But that places a lot of evidentiary burden on employers. Therefore, simply aligning the charges based on your disciplinary code or disciplinary procedures will help go a long way in making sure that employees who really act in contravention of the company's rules and processes are caught and then they are dealt with accordingly. Thanks, Graham. If there are no questions, I will leave it to you.
Thanks, Amandla. Thanks for putting a very complex issue so succinctly. I think that helps us enormously. So thank you very, very much. Melissa, I think you're next on a constructive dismissal case in the Labour Court, Mokhomotsi versus Sanlam. So back to you.
Yes, thanks, Graham. So this case deals with a constructive dismissal case where the employee was diagnosed with depression and acute anxiety. And he was an IT specialist. His title was known as an ethical hacker. So his skills were scarce and very highly regarded. And he resigned and claimed a constructive dismissal dispute at the CCMA. But the CCMA dismissed his constructive dismissal claim and said that he simply resigned and there was no intolerable work environment that was created. And he took the matter on to review. And one of the grounds of his review at the Labour Court was at the time of his resignation, his employer was aware that he was suffering from depression and anxiety, and the commissioner failed to take this into account. So there were various incidents that led up to the employee's resignation that could be seen as acts of misconduct. So for example, his mother fell ill and he went on extended leave without authorization. And then he called his colleagues liars. And then he'd made it known to his employer throughout this process that he was, however, suffering from acute depression. He had a lowered mood and he experienced a lot of family and work stress, and he had a medical certificate to support this. His performance was also the poorest it had ever been since he'd started at the company. He was a poor timekeeper and his relationships with his colleagues was poor. And the court held that the prevalence of stress and mental health on the workplace is a phenomenon that requires the acknowledgement of employers. It's not something that needs to be stigmatized. And the court referred to commentary, which showed that workplace stress and depression and anxiety disorders is costing the national economy 40.6 billion rand per year, or 2.2% of our GDP. The court held that there was no evidence at all that the company had even considered that the employee was incapacitated due to ill health, and rather proceeded on a disciplinary basis where he had misconducted himself. And the court held that if the company had actually taken into account the fact that this person was suffering from a mental illness, his acts of misconduct should have been seen in a different light. And that should also be borne in mind when he actually resigned. So the court held that ignoring mental health issues of an employee could render the conduct of the employer unfair. And the court said that even though this might be very onerous for an employer, it has to be accepted that this is a necessary requirement of this day and age where workplace depression, anxiety, and stress is extremely prevalent. And so in that case, the court held that the employee was actually constructively dismissed and that such dismissal was unfair. Thanks.
Oh, interesting case, very interesting. Thank you. And then your next one is a misconduct dismissal case. It's the Independent Risk Distributors SA versus David and Blauwell.
Yes, thanks, Graham. So this case deals with the difference between insubordination and gross insubordination. So in this case, the employee was a sales representative and he was called together with the sales team to a meeting with the CEO. And in that meeting, the CEO wanted to address the team's underperformance, and he instructed all the sales representatives to go home and then reflect on their performance and return to the office the next day. So the employee asked a question of clarification. He asked the CEO, why did he form part of the poor performers that were being sent home? And he was informed by the CEO that this was because the non-performance was a team issue. There appeared to be some issue with the way in which he might have asked the question, and the employer considered the way that he asked the question and his question of clarification to be gross insubordination, because his questioning was challenging the instruction of the CEO and that this was done in the presence of his colleagues. So it was related to the context and how he asked the question, his tone, and the people who were present when he asked the question. And the employee led evidence to say that all he did was ask a question of clarification, but he didn't refuse to carry out the instruction of the CEO. He sought to clarify something, he accepted the explanation, and then he left as was instructed by the CEO. And the court held that insubordination generally refers to the disregard for an employer's authority or lawful and reasonable instructions. So it occurs when an employee refuses to accept the authority of a person in a position of authority, and it includes a willful and serious refusal to adhere to lawful and reasonable instructions of the employer. So it's a deliberate and serious challenge to authority. This is compared to insolence, which is offensive or disrespectful behavior. It could be seen as cheekiness or rudeness or contemptuous or insulting conduct in the workplace. So there was a distinction between insubordination and then insolence. And the court held that mere insubordination and insolence is not enough to justify dismissal unless it's actually very serious and willful. So the sanction of dismissal is only going to be reserved for instances where you have gross insolence or gross insubordination, which is a willful flouting of the instructions of the employer. And in this case, the court said that the employee's conduct didn't warrant dismissal because he had ultimately complied with the instruction. He went home as he was instructed. And this disrespect, even though in the context and the tone in which he might have said something, it wasn't serious, it wasn't persistent, it wasn't deliberate, and in these circumstances, it did not amount to gross insubordination. The court mentioned that just because an employee is in the workplace doesn't mean they lose their constitutional right to freedom of expression, and they ought to be allowed to ask questions of clarification without it constituting serious misconduct and them being dismissed as a result of that. So the court held in this case that the dismissal was substantively unfair. Thanks, Graham.
Thanks, but that's very interesting. Thank you. Right. We're going to deal with the ability to make deductions from remuneration, and it's in terms of the Basic Conditions of Employment Act. It's a High Court decision, and it's going to be presented. I'm going to let you pronounce the name, Sibu, because I'll make a mess of it. But you pronounce the name. And yeah, Sibu is a partner, a newly admitted partner in the department. He's our rising star. Over to you, Sibu.
Thanks, Graham. I'm assuming the name you want me to pronounce is Amatole, which you had done earlier. So it's quite an easy one, Graham. I'm disappointed.
Try the first name, Sibu.
Okay. Well, I mean, there's 11 applicants, so I'm not going to go through all of them. But it is Thandokazi Amanda Bitekaya. That is it. So it's Thandokazi and 10 others against the Amatole District Municipality. So in this case, the 11 applicants had actually been dismissed for having taken part in a strike, which was unlawful. In fact, sorry, they were not dismissed. My apologies. I'm so used to people being dismissed for taking part in a strike. So it's 11 of them who had taken part in this unlawful strike. And at the time, the employer had actually paid them their salaries while they were taking part in the strike. But what the employer did was they announced in the media that they would apply the principle of no work, no pay. So 5 months later, the employer then sent out a notice to these employees that they're actually going to effect deductions from their remuneration arising from them having taken part in the strike, in the unlawful strike some 5 months ago. So there was no consultation with these employees. The employer just decided that, they would do this over a period of 4 months. And instead they went on and did it over a period of 2 months. So this case then went before the High Court on an urgent basis, where the employees were seeking an interdict prohibiting the employer from making these deductions. Now, the court granted the interim interdict and actually instructed the employer to pay back any monies that had actually been paid to the employees at that time until the matter was determined on the return date. So on the return date, there was quite a number of issues that the court had to deal with or grapple with. And I think as a starting point, it's important that we just have a look at what Section 67 of the Labor Relations Act says, because the employer had relied on Section 67 of the Labor Relations Act to make these deductions. And what Section 67 says is that, I thought I had it in front of me, but I've lost it. Okay, so Section 67.3 says that An employer is not obliged to remunerate an employee for services that the employee does not render during a protected strike or a protected lockout, right? So that's 67.3. So the court went on to say, well, section 67.3 deals with a protected strike. So this is actually the wrong basis, right? But let's look at section 68, and it's section 68 that actually deals with unprotected strikes. The court went on to say, well, when we actually look at section 68, it actually doesn't deal with whether or not an employer should remunerate employees for taking part in an unlawful strike. But the court reasoned that logically, employees will not be entitled to being paid if they participate in an unlawful strike, as is the case where they participate in a lawful strike. So even though the LRA doesn't specifically provide for this, the court said, logic dictates that this should be the case. So the next thing that the court then needed to determine was around section 34 of the BCEA, which deals with instances when an employer can actually make deductions on the remuneration that is paid to employees. So as I've indicated earlier, in this case, the employer had actually implemented these deductions without following any process, without consulting the employees. And those are some of the reasons why they'd actually brought the case before the court. They were not party to this decision. They didn't have a say on the recovery mechanism, and they also didn't consent to the employer making deductions. So section 34.1 of the BCEA provides that an employer may not make any deduction from an employee's remuneration unless the employee in writing agrees to the deduction in respect of a debt specified in the agreement, or the deduction is required or permitted in terms of law, a collective agreement, court order, or arbitration award. The section goes on, to speak of when exactly deductions may be made, but I won't go into that for now. So that's really what the crux of this case became. It became an interpretation of section 34.1 of the BCEA. Now, in the judgment, the judge refers to a lot of his own judgments where he had dealt with similar matters. So I think he really enjoys his judgments. But I think the finding that he makes, which I thought was quite important, it appears in paragraph, so paragraph 54 and 57, and I'll just read them quickly. He says, the provisions of subsection 5 do not in itself grant the employer a remedy or right to apply set-off, even in a scenario where there has been an error in calculating the employee's remuneration. The section merely, in my view, confirms the category of deductions that an employee cannot be expected to challenge on the basis that she or he had no entitlement to in the first place due to it constituting an obvious overpayment or arithmetic miscalculation. And then paragraph 57, which I think is quite an important one to consider, is the judge said, I've also said above that notwithstanding the universal no work, no pay principle, its invocation does not elevate it to one that is permitted in terms of a law as envisaged by section 34.1b. So 34.1b says that an employer may make that deduction if the law permits it. So the judge says this notion of no work, no pay is actually not a law. He then goes on to say, the respondent should have gone further in the interdict proceedings and have asked for leave to deduct remuneration it was entitled to withhold on the basis of the established principle in the event of the court finding in its favor that the strike was unlawful. So the way I read this is essentially they're saying, so you should not actually implement the no work, no pay principle if you actually don't have a court order that enables you to do so. So when you are busy with a strike interdict, in your notice of motion, if you want to implement no work, no pay, in your notice of motion, you should actually have a prayer where you ask the judge to actually allow you to withhold or to deduct remuneration from employees resulting from them having not worked. And I guess this is what happens when people go to the High Court for labor law matters. So in the end, you know, the court really found that the applicants were entitled to final relief. You know, they had not been consulted. There was no law permitting the employer to come 5 months after the fact and make a deduction. The employees had not consented. You know, they had not been given an opportunity to show cause as to why this deduction should not happen. So final relief was then granted to the employees and the employer was ordered to pay costs.
Thanks, Sabu. Then on to the last case of the day, which is a restraint of trade case. It's a Planet Fitness versus Bursky case. And Sabu, you're presenting on that as well. Thank you.
Yeah, thanks, Graham. So this is a fairly straightforward case, quite a quick judgment. But essentially, we've got Mr. Bursky, who was working at Planet Fitness. When he started working for Planet Fitness, he signed a contract in terms of which he was a regional sales manager. Now, his letter of appointment had an appendix to it, and this appendix contained the restraint covenant that would be applicable to him. The restraint provided that he's not allowed to work for a competitor, you know, within a period of 6 months, and the region that it covered was the entire South Africa. After a few years, he was then promoted to national sales manager, and this letter of offer as well made reference to Appendix A. Again, Appendix A was apparently another restraint. So he was then dismissed by Planet Fitness. When Planet Fitness dismissed him, he immediately started working for Virgin Active, who is obviously a competitor of Planet Fitness. Now, in the labor court, Mr. Bursky raised a point in limine, 2 points in limine. He stated that the restraint that Planet Fitness was relying on was actually superseded by the contract that he had entered into when he was promoted. And secondly, that contract was actually, or rather that restraint and the contract were actually not before the court. So Planet Fitness could actually not invoke, or rather they were invoking the wrong contract. Those are the points that he raised, and the judge, in dealing with these points in limine, first looked at whether or not the incorrect contract or the incorrect restraint was being relied on. And the judge went on to speak about the fact that Planet Fitness was seeking to actually limit his constitutional right, you know, to trade in any manner that he wants to. And the court said that, well, if you're trying to limit someone's constitutional right, the least you can do is actually bring us the right papers. And because they had actually brought the wrong contract, you know, there was no dispute about the fact that they had actually attached the appendix of the 2014 contract to the 2021 contract, and that's what they were relying on. So there was no dispute about the fact that it was the wrong appendix or the wrong restraint. So the court found that, well, you can't rely on the wrong restraint. You needed to bring us the right contract. And based on that, the application should have been dismissed, or rather should be dismissed. But the court went on to determine whether or not this was a reasonable restraint. You know, the judge said, let's say I am wrong, or I'm being overly technical because the terms of the two restraints, I'm told they are similar or they are the same. So let me now determine whether or not this restraint is actually unreasonable. And in doing so, she then found that, well, Planet Fitness had actually not set out what proprietary interest they're actually trying to protect. They had said that, you know, well, the proprietary interest is too confidential and they actually don't want to expose their trade secrets. So the court went on to find that, you know, at the very least, if they were so worried or so concerned, they should have at least submitted an affidavit confidentially and sought agreement from the respondent, you know, that this is something that would be handled in a confidential manner. They had presented certain minutes of some meeting. The court found that those minutes were not confidential information. And they'd also indicated that some of the trade secrets they want to protect related to partnerships that they have, commercial partnerships that they had. So the court found that, well, those commercial partnerships are in the public domain, so they are not a secret. So the court found that there was actually no trade secret, or there was no proprietary interest that was pleaded or that required protection. So on the basis of submitting the wrong restraint and not actually setting out a proprietary interest, this application was then dismissed.
Thank you, Sibu. And that then brings us to the end of our program. I'd like to thank all of you participants for staying with us for the duration. I'd like to thank Mbali and Amandla, who presented for the first time. Well done to you both. You did a fantastic job. I'd like to thank all the panelists for the work that they did. Thank you very, very much. I'd like to wish you all a good Christmas and a new year, and we look forward to seeing you in the new year. Thank you, everybody, for your participation. We will be sending the recording and the case references to you. Thank you all. Thank you, panelists. Cheers.